Hi, everyone. It's Russ Nestovich with Nestovich Law. Thank you for joining us this evening. Tonight, we have a tip for you about powers of attorney and really about having co-agents in your power of attorney. So generally, when we deal with our clients, many of you are our clients, we give the following advice. We generally discourage, unless there's a really, really good reason, co-anything. We discourage co-executors, we discourage co-trustees, we discourage co-agents in your power of attorney or your healthcare power of attorney. And the reason we generally discourage co's is because we want one person in charge. So we encourage you to have as many backups as you want in any of those positions, but we don't want two people in charge at the same time, because two people in charge at the same time eventually will lead to two opinions. And when you have two opinions, you've got a problem. However, there's yet another reason that actually came up today for which we discourage co-agents specifically in your power of attorney. So occasionally clients will say to us, look, we appreciate the advice, but for this reason or that reason, we still want to have co-agents. And our response is always, look, it's your plan and not ours, and it's our job to give you advice and guidance, but to implement the plan that you want to implement. So if you insist on doing it a certain way, we can help you do it that way. So we have a client who has co-agents in their durable power of attorney. And the gentleman who has the co-agents in his durable power of attorney has now gotten somewhat frail and needs a little bit more help than he may have needed in the past. And unfortunately, his brokerage account, or the firm that holds his brokerage account, has refused to accept the durable power of attorney. And the reason they've refused to accept it specifically is because of the co-agents. They basically said that it is their policy that when you have multiple agents on the durable power of attorney, they won't accept that durable power of attorney because it causes them risk and liability. If one agent calls them one day and gives them instructions to do one thing, and the other agent calls them 5 minutes later and gives them instructions to do something else, we've got a problem. So now we're dealing with that gentleman, and we're dealing with his two agents, his children, and we're going to have one of the agents resign as co-agent. So luckily, the way that we draft the powers of attorney, one of the agents can resign or basically say that they are unwilling to act and allow the other agent to act individually. And luckily for us, this person's agents have gotten together and have come to a decision of who they want to be able to act and who is willing to step down. If they weren't as willing, we would potentially have a pretty serious problem. And this is why we give the advice of co-agents are usually a bad idea. So again, just reiterating the point, not only because when you have two people, you have two opinions, but also because some financial institutions don't want to deal with a power of attorney that has co-agents. We always encourage our clients to have as many backups as they want, but to pick one person to be in charge. And that's not only true when dealing with powers of attorney, it's also true for things like healthcare power of attorney, executors, trustees, etc., unless there's a good reason to do so, and there sometimes is. We'll be covering some of those reasons in future videos, and we're also happy to answer any of your other questions in future videos. So give us a like, a comment, a share. I think that the kids on YouTube say smash that like button. So if you like this, smash that subscribe button or the like button or whatever there is to smash. And we're happy to keep doing more videos and answering your questions. So with that, hope you have a great evening and look forward to speaking with you again tomorrow. Take care.